All council has indicated all discovery is complete in this matter. And we were discussing dates. I'll set preliminary examination in person, June 3rd, 2025, 9 AM. That's before me.
Thank you, Aaron.
Bond will continue.
Thank you, Connor.
Thank you.
I'll stop by and chat with you. I'm requesting. I'll try to stop by and talk to you.
Huh? So cool. It's no, it's one of the ones with the big flap. It's like, no, it's gonna be, because you like those, though. You don't know? Oh, so if it shows up, you might like run out. Never mind. We'll talk later. Let's call the case. People of the state of Michigan versus Todd Emmerman. That would be fun.
I love this job.
Good morning, Your Honor. Jennifer Douglas for the people, P72748.
And good morning, Laura Yagi, Assistant Public Defender, sort of but mainly on behalf of Mr. Ammerman. Your Honor, Mr. Ammerman is on Zoom. I was just trying to be in a breakout room with him. My understanding is he's not in Your Honor Zoom. He's in Judge Freshour's Zoom.
Oh, that works.
It does not.
I know.
I don't know what's going on. I was,
Okay, all right, it's okay. Yeah. So what do you need to have happen? You need him to get to my Zoom.
So, Your Honor, I was going to ask for an adjournment anyways. I did fill out a green sheet. I would ask for an adjournment and to allow us time to get him in the right place and to get him here.
Judge Freshour staff has not been able to communicate well with him to get out of their Zoom.
What's that? He won't get out of there.
They tried to send him text messages, but
So have you talked to him about signing into this Zoom?
I have not. I have attempted, but I have not been successful in.
Okay, because Judge Freshour staff, I was just informed, are trying to communicate with him to get him to sign into the right Zoom. It's not going well.
Yeah, that does not surprise me.
Oh, well, okay. Appreciate your candor.
I really don't know what is going on, but
Shaggy, I'll let you out the hook.
thank you.
Is there any objection from the people to the brief adjournment?
Your Honor, there's no objection. I don't have any information that suggests that Mr. Ammerman is compliant.
All right. I mean, he theoretically, I guess, is next door, so he. All right. It's been 1 week now. Can you explain this to him in a week?
I will do my very best.
All right. Probable cause conference, May 1st, 2025.
Thank you, Your Honor.
You're welcome, Ms. Aggie. Court calls case People versus Quentin Williams.
Alexander, on behalf of the people, Your Honor.
Morning, Your Honor. Wendy Burnwell, P42505, on behalf of Mr. Quentin Williams.
Your name, sir?
Quinn Williams, thank you.
Good.
Okay, what are we doing?
I'm requesting an exam, Judge,
All discovery is complete.
upon information and belief. I believe so.
What's that mean?
I have electronic as well as paper discovery, Judge.
You're not available the week of the 6th, right?
One split second, Judge.
Well, you just looked it up before. It said,
Yeah, I have to look at the actual thing.
go for it. I was trying to be nice.
I'm available on the 5th.
Okay. But we won't be here on the 5th.
Oh,
Well, I'll be here, but we won't be holding exams on the 5th.
okay.
It's the 6th or the 13th?
One split second, Judge.
I know the answer. It's gonna be the 13th. Because you're not available the 6th, because we've already gone through this. But that's okay, I'll wait.
Donna, can you guys do it on a Friday?
Can I do what?
I'm available on the 9th of May.
The judge just locked in a preliminary exam date lightning fast. Speed matters in court. Quick scheduling prevents cases from dragging on forever. But here's a question for you. Do you think moving this fast helps justice or risks skipping over important details?
Okay, good.
I mean, jury trial on the 13th,
Okay,
so I don't want to call that.
we do exams every Tuesday.
Okay. The 20th. Come on now.
People have no objection to that.
When I'm available, guys, I'm in trials.
Preliminary examination, May 20th, 2025, 9 a.m. That's before, please. Judge Bar.
Available there.
Will continue. Thank you.
Okay. All right.
Court calls the case, People versus Cody Jolly. Zen Zoom.
Andrew Childers appearing on behalf. Yes. Did you ever have any luck? Oh. No. I'm sorry, no.
Mr. Jolly,
Yeah.
he's unmuted. Well, he's muted, so I can't. Mr. Jolly, can you hear me?
Classic Zoom court chaos. Wrong judge, wrong room, wrong everything. This is what happens when real-life court meets virtual court. Be honest, have you ever logged into the wrong Zoom meeting at work or school?
I
Jolly.
know he hasn't been up. Is he responding at all to us?
No, Your Honor, he's just sitting there.
Okay. What are we gonna do on this?
What I can tell the court, there was discussions between myself, Mr. Jolly also has cases pending in 15th District Court. Prosecutor there had spoken with jail staff about possibly getting a petition if the CMH worker in the jail. That does not appear to be something that can be done. What we then tried to do, or are in the process of trying to do, is work out a plea with Mr. Jolly. Mr. Chabalowski, who's the 15th District Court prosecutor, and Mr. Gaddy Mr. Gaddy just kind of going as standby counsel, attempted to go to the jail and speak with Mr. Jolly, I believe last week or the week before, but there was an issue with actually getting him to come up and speak with them, so they weren't able to facilitate any conversation about any sort of resolution.
Actually, yeah, Your Honor, Mr. Chablowski and I, Mike Getty from the Public Defender's Office, Judge Perry had, he has not asked for standby counsel, but just in case he changes his mind while he's talking to the prosecutor, she asked if I would go, and I agreed. And we tried to go down. It was not a good time for the jail, so we're planning on doing it later this week, and we haven't had a chance. We're hoping to go tomorrow.
Okay.
So we did attempt to see him, but he didn't refuse us. But I mean, to be candid, he's refused everything else.
So what do you wish for me to do?
I'm merely a reporter in this.
Yeah, I know, I got you. Well, until we can figure something out, I mean, this is sort of at a standstill. I mean,
I guess at this point, we'll give them another chance to see if we can have some sort of conversation.
that's fine. So what I will do, I think, haven't we sent him for comp already?
We found
Comp.
competent, although the thing that struck me about that is that CFP relied on their earlier finding of competency, having not seen him for all.
Correct. So, all right, I'll adjourn the probable cause conference in this case to May 22nd, 2025, 9 AM. Bond continued. All right, thank you. All right, we're all set. Thank you, Lee.
Thank you.
Court calls the case People versus Byron Blair.
Honor Alexis Plumey appearing with and on behalf of Mr. Blair, who is approaching. And Mr. Blair, could you state your full name?
Byron James Blair.
All right. I have before me a plea form. Indicates he would be pleading guilty to the charge of retail fraud, second degree, the 1-year offense. Upon a successful plea to that charge, count 1 retail fraud and the first would be dismissed.
Yes, that is correct, Your Honor. I have gone over that offer with him as well as an advice of rights, which should be in the file as well.
You have it. All right, very good. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
State your name.
Byron Blair.
All right. Sir, it is this court's understanding that you're going to plead guilty to the charge of retail fraud in the second degree.
Yes.
That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes, sir.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in the 15th District Court. You
Okay.
understand that, sir?
Okay.
Okay. Understanding all of that, do you still wish to plead guilty?
Yes.
Are you sure that's what you want to do?
Yeah. You scared me. Like, who was Valvo? Like, I'm
So-
sorry. You like, are you
That's-
sure?
Like, who is Valvo?
Talked about the
Oh, she's the
judge
chief
in
judge of the 15th District Court.
in downtown Ann Arbor. So remember, Judge Simpson is not going to sentence you.
Oh,
You're gonna be
I
sentenced
got you. I got you. I got you. I got you.
Okay, what do you got me for? What are you telling me?
No, I understand what you were saying. Look, the way you said it was like I was just imagining the executioner or something. Like, like I was scared for a minute. Like, who was Valvo?
Oh, so you
Like,
thought Judge Valvo was an executioner?
Yeah, like you know, it's not gonna be me.
No, I'll call her today and let her know.
No, no,
No, I mean, I just to share that information.
no, sir. I'm sorry.
Mr. Jolly's case is at a standstill, and notice the competency issue here. The court relied on an older report without a fresh in-person evaluation. That's a subtle but important tension in law, procedure versus practical access. Do you think he should have been reevaluated?
Okay, I'm sorry.
Wow, and of all the judges. Okay, you're clear now. I'm just taking your plea. You would have a
Okay.
right to have me sentence you, but I need you to understand that this case is set not to be sentenced, that I would not do the sentencing.
Okay, I got you.
You got it?
I got
You okay with that?
Yes, I'm cool.
Okay, so understanding all of that now. Do you still wish to plead guilty to the
Yes, sir, I
charge?
do.
You do?
Yes,
All right,
yes,
and
sir.
to the charge of retail fraud second, how do you plead?
Guilty, sir.
All right, now you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, yeah.
All right, you signed an advice of rights form, is that correct?
Yes, I did.
Any question regarding any of those rights?
No, sir.
Look at paragraph 5, you'll see a copy on the podium there. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, yes.
You understand you're giving up your right to appeal of right.
Yes, I did.
Are you on probation or parole?
I just got on probation on the 11th in Detroit. Yeah.
So you're off, you're not under the jurisdiction of any court at this time.
I'm on probation. No.
He's on
No, I
probation out
just
of
took
Wayne
probation. I'm
County.
trying to get all of my stuff together. I've been on.
I don't know what that meant. Counsel?
He was not on probation or parole at the time of the
No.
offense. He has now recently been sentenced to
Thank you.
probation.
Yeah, for old case, 2020 or something.
All right. Has anybody promised you anything other than what's been stated here today to get you to plead to this charge?
Nope,
Anybody threaten you or coerce you?
no, sir.
You're doing this voluntarily
Yes, I am.
of your own free will. And because you believe that you're guilty of this offense?
Yes, I do.
June 1st, 2024, at the location of 303 South State Street, City of Ann Arbor, Washtenaw County, State of Michigan. Tell this court what you did on that date involving the Emden store that makes you believe that you're guilty of this.
I exited with some items, but they got returned back, some Jordan shirts, a couple hats or something like that.
Okay, so you went into the store.
Yeah, I exited. Yeah, I didn't pay for it.
Okay, I got it. So you went into the store, you took property that
Yeah,
the store had for sale.
yes,
They were open to the public,
yes.
and you tried to walk out of the store
Yes, I
without
did.
paying for that.
Yes, I did.
Is that correct?
So,
All right. And you didn't have anybody's permission to do that?
no, I didn't have nobody.
All right. Was the value, is this on value or prior?
Value.
All right. So was the value total of the property that you tried to take out of the store, was that in excess of $200?
Yes, it was.
All right, counsel, have I complied with the court rule, and would it be proper to accept this defendant's plea?
People are satisfied.
Defense is also satisfied.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. The pre-sentence investigation and report is ordered through 15th District Court probation. Sentencing will be May 20th, 2025, 9 a.m. before Judge Valvo.
Okay.
Judge Valvo. Not execution.
I know.
All right.
And Your Honor,
I'm
I-
gonna call her though.
may I briefly address bond?
Yeah, go ahead.
Okay. Your Honor, we're asking the court to consider a personal bond for Mr. Blair. The reason that bond is set high on this file is because there were a couple of failures to appear in the past. Mr. Blair has explained that those failures to appear were due both to him being in and out of the hospital. He does suffer with congestive heart failure. And that's one of the reasons he would like to be out of custody to continue his medical treatment, as well as going back and forth between this county and the Wayne County Jail. He has now resolved all of his cases in Wayne County. I don't see that he has any out-of-county holds. He was recently placed on probation in Wayne County, so he's a little worried about picking up violations and not getting the programming aspects of his probation completed because of being in custody here. If he was released, he would be going back to the Delanis Center to live for right now. He is participating in their Pathways program. He has a caseworker there as well as a CMH caseworker that he's been seeing in the jail. He did provide me with their contact information. And he does have a phone, so we'll be able to reach him. He just wants the court to know that he did not mean to miss his court dates, and would like the court to consider allowing a personal bond. His other cases in this county are retail frauds. They all have very low bonds set right now, just so that he was getting credit while this case was holding him. I do believe his other cases in 15th,
No,
he
no.
he would get a.
Please go on.
I'm sorry, I do believe his other cases in 15th would revert to personal bonds if he was given a personal bond on this case.
That executioner slip was funny, but it revealed something deeper. Courtroom language can sound terrifying to the average person. The judge kept it calm and clarified, which builds trust. What do you think? Should judges lighten the tone more often in moments like this?
Any response?
Your Honor, this is one of 5 pending cases holding the defendant right now. They're all retail fraud. Yeah, I'm concerned with, I understand he's saying he was sick, but he did have, I think, at least 3 bench warrants in this case. So I'm gonna request that bond continue at least until the time of the PSIR.
I tried, but I was in the hospital. And then one time y'all pulled it back because y'all had me mistaken. Oh, can I talk?
You were in the hospital, you were going
I
back and
called
forth
up here. I
between Wayne
called your
County and
court up.
here.
I called your office up here, and I was known that it was a mistake because y'all had me down as being in custody doing
Y'all,
Zoom.
that's me.
Not y'all, okay.
Go ahead, no, I'm listening.
The Washtenaw County court system, right?
Oh, that big y'all.
Okay, yeah, the big
Okay,
y'all.
yeah, okay, go ahead.
It was a mix. Okay. One incident. I left here. I wasn't released from custody because I was picked up by Wayne County. I was held there, didn't Zoom. So when I get out of Wayne County on tether, I had a warrant for you instantly there.
Acting Ruby, why are you nodding like all this is? No, go ahead.
Like this is crazy. I just been ping ponging back and forth between Wayne County and Washington. So while I was in Wayne County, they never zoomed me to come here. So when they kicked me out on tether, when I paid bond, I get out on tether, right? They say you have a warrant in Washington County. For what? For not going to court. I said, okay. I come out here to Washington County. I ended up in custody trying to figure out how to turn myself in. I come back up in here, y'all set me another court date. Now guess what
Y'all,
happened?
that's it, big y'all.
The Washington County court system.
Okay, go ahead.
Okay, now this is what happens the next time. I'm on tether. They cut my tether off because I was in here so long waiting to see you that my tether went dead. Now I got to go back to the new Wayne County jail, which is like backed up 2 to 3 weeks just to get out on tether. So by the time I get back out on tether, they had me another paper again to say you would now have another warrant in Washington County for missing court. I'm ping ponging back and forth. When I just got my tether off on the 11th, they called y'all Washington County.
Y'all, all of us?
They called the courts up.
Okay.
They let y'all know.
I'm just trying to
Because you gotta have a lien. You gotta have a lien when you get sentenced to probation time. So I went in prepared to come in, right? And this and that. They told me, advisor release, take care of it when you get up here. So I got up here. I got with my caseworker, this, that. I was supposed to be going to this transitional housing stuff set up, this and that. I made sure I had my housing stuff set up here first. And then now I'm trying to see what you.
If I give you a PR, will you stop?
If you don't send me back to Detroit and ping pong me, yes. Whoever said that, yes. That's the first time I ever been able to talk.
No, I don't believe that for a minute. You are too good at talking. That to be your first time.
All right, sir.
Well, he's got other holds that are gonna hold him in, but if you're asking me to reduce this bond, it right now it's at 1,000 cash or surety.
No, they said that the bonds that they gave me, that it will convert into.
So he wants a personal bond on this case because that would make it a lot easier to get personal bonds on his other Washtenaw County.
Oh, I got it. I was just ready to rule and he started talking again.
I think he did a great job.
He did. He did a fantastic
Better than me.
job for the last hour.
Yes, Your Honor.
That's what.
Yes, there were other holds. I said yes.
And
4 other cases that.
four other cases, that's what you were saying.
Yeah.
Before we.
And I'll just put the course of information to you. I see a 2019 case, 2022 case, 2023 case, and a 2024 case.
Grant the request to reduce his bond. They'll set his bond at $1,000 personal recognizance bond.
Thank you.
You're welcome.
Thank
Take care.
you. too,
And
sir.
I've already sent a message to Judge Valvo. She's waiting for you. All right, take care. Bye-bye.
All right, big guy.
Court calls the case People versus Deshaun Clifton.
Your Honor. Assistant Public Defender Dr. Lee on behalf of Mr. Clifton. And Your Honor, today we're going to be requesting an adjournment. Mr. Clifton, can you state your name?
Deshaun Clifton.
Thank you.
And Your Honor, today we're going to be requesting an adjournment of the PCC in order to receive some outstanding media discovery of the dash cam and body camera. I have prepared a green sheet.
Okay, you have a green sheet?
I do.
Excellent. Probable cause conference will be adjourned May 15th, 2025, 9 a.m. Bond continued.
Your Honor.
Thank you. Case People versus Zachary Bruno.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Bruno. Mr. Bruno, will you state your name for the record?
Zachary Bruno.
Thank you.
Your Honor, we're asking that this matter be set for a preliminary exam.
All discovery is complete.
To our knowledge, yes.
People have their witnesses available to 6. Pardon?
We will try it.
Preliminary examination in person, May 6, 2025 at 9 a.m. before Judge Perry. Bond will continue.
Thank you.
All right, thank you.
Oh, that I passed it? I thought he was on his way. Court, let's call the case. People versus Antonio Cornelius.
And good morning, again, Laura Yagi, Assistant Public Defender, with and on behalf of Mr. Cornelius, who's approaching. Can you say your name for the court?
Antonio Cornelius.
And Your Honor, we would respectfully ask for this to be set for exam.
You seem to be doing better than your last case. Okay.
To
Discovery is complete.
our knowledge, Your Honor.
All right. People have their witnesses available on the 6th. Preliminary examination in person, May 6, 2025. 9 a.m. Sorry. 12 p.m., 12 noon, before me.
The plea was accepted. Count 1 dismissed. Sentencing date set. This was a textbook plea hearing. Did you notice how the judge confirmed rights waivers, penalties, and the factual basis? That's due process in action. Do you think the defendant truly made the plea voluntarily?
Bond will continue.
Thank you, Your Honor.
Thank you. Court case, People versus Gregory Davis.
And that is me again. Laura Yagi, Assistant Public Defender, with and on behalf of Mr. Davis, who is approaching. Mr. Davis, could you say your name for the court?
Gregory Davis.
Thank you.
Your Honor, this has been postponed a couple times. And we were trying to see if we could consolidate it with a case that we were told is upcoming. That case has not been charged or authorized. So we are asking for an exam date at this time. In terms of discovery, I did request the 911 call back in March. We don't have it, but I don't want to keep waiting. Mr. Davis is held in jail on this, and so I can't keep adjourning it just for that.
People have their witnesses available to 6.
We will try our best, and Ms. Yagi, I thought we sent that 911 call to you a few weeks ago, so I will check on that again.
Thank you.
Preliminary examination, May 6, 2025. 9 a.m. before Judge Perry.
Your Honor, may I briefly just address bond?
Briefly.
Okay, this is one of 2 cases that are holding him, or he has 1 or 2 cases out of 14B. One is just traffic, one is DV. He has done over 50 some days on the DV 14B case. He was set for final settlement tomorrow, but then he was removed from the docket because they didn't know he was in jail. And somehow he had just been sitting with that outstanding warrant without being arraigned on it. He is now set to go to 14B on Monday. And obviously, I don't know what they're going to do, but I would ask if the court would consider lowering his bond. It's a 5,000 cash surety right now. I would ask for a 10% provision to be on there, because just in case they do give him a personal bond in 14B, which I'm very optimistic that they will, because he's done so much time on that case as it is. He has a job at Cracker Barrel waiting for him. And just to be candid, Your Honor, I've been representing him. This is, I think, our third PCC together. I've met with him several times. He's met with CMH in the interim. Personally, I've noticed a difference. When I first met with him, he was very loud. He was agitated. We had a really great conversation, and he actually thanked me for pointing out to him that he was so loud. He's met with CMH. He's been so genuinely reflective since. And I really mean that. I don't say that, as Your Honor knows, I don't say that about all clients. So I think he's really done a lot of reflection. And so I would ask if the court would consider a 10% provision.
Response from the people?
Your Honor, I can't speak to what 14B is going to do. Obviously, Mr. Davis's case, the issue that we have with Mr. Davis, I think, is primarily the fact that he had a case pending for exam. That case did end up being dismissed at this point because we had a witness that was not available, an officer that was going to be gone for quite some time. When one of Mr. Davis's cases was pending, we had a new incident where he showed up to that victim who's his mother's house and was trying to get in. Essentially, we have the MDLB on that case. We have some bond concerns, obviously, there. The domestic violence case, I don't believe it's related to some of these other incidents. The new warrant, I've heard, we do not have a response back on that further yet. But that is a completely unrelated UDAA allegation as well. Mr. Davis, should he be released? I'll leave that to the court's discretion. I do know that Mr. Davis has, I can appreciate that Mr. Davis has been improving. I think that may be because he's had a chance to essentially detox. I know that he was under the influence of apparently narcotics, I think, at the time of this incident. And Mr. Davis has a warrant out of the 35th District Court for controlled substance possession. I don't know if he is aware that that is out there. He was arraigned on that on November 10th of 2024. And that bench warrant, let's see, was issued a few weeks after that, so November of 2024. So if he were to be released, I don't know if there's a testing order on this file. We'll be requesting that, obviously, in his history. And hopefully he'll be able to get that one as well.
Your Honor, may I respond very briefly? I just have to clarify something.
Okay.
Ms. McDuffie stated he went to the victim's address. He was on house arrest there. He was supposed to be there. So this is not a case where he returned to the victim's address against the court order. He was literally on house arrest there at the address with his mom, who they're saying is the victim. But he was supposed to be there. So I just have to clarify that for the record.
Are we done?
Yes, Your Honor.
Okay, I'm going to grant your request.
Thank you.
His bond will be set at 5,000. I'll give a 10% privilege on that. Thank you.
Thank you.
Are there any contact orders on this matter? I'm not sure what Ms. Jackie was referring to. We got a contact order with it at the time. So
That is not true. He had a consensual contact order. We have to be clear for the record. It is not true that he had a no contact order. He was on house arrest there at his mother's address. He was allowed to have contact with her. He was supposed.
Is that Ms. Freeman?
It is Martha Freeman, yeah.
Okay, what I have is, I have a no contact with her at this time.
With this case, not with the other case.
Okay.
Thank you.
thank you for your concern.
Thank you. Okay, super.
Thanks. Court calls the case, People versus London Dottery. Oh, boy.
Court shall feast the first assistant public defender on behalf of Mr. London Dottery, who's approaching the podium.
Did you apologize to Ms. Constantine?
I did, Judge.
Did
She
you?
graciously forgave.
Did she accept your apology?
She said she did. I
She
pray
said
she
she
did.
did?
Yeah, she said she did.
Okay,
So I hope she really did. She said she did.
okay.
Thank you. State your name, sir.
London Dottery.
Thank you.
Thank you, Judge. I have submitted a green sheet. We're requesting a 3 or 4th adjournment. We are undergoing mitigation, and I believe we're also investigating a potential motion.
How much time?
3 to 4 weeks, please.
Wow.
whichever one is better for the court.
No. It's just
Not-
I see how you snuck.
Not picking my date, just,
I know. I saw how you did that. May 20th,
thank you, Judge.
2025. 9 a.m. bond will continue.
All right,
Oh, May 20th is 22nd.
the 22nd,
Yes.
thank you, Judge.
Thank you, Miss.
Bond reduced to $1,000 personal recognizance. That's a big shift. Despite past failures to appear, the court weighed his medical needs, probation logistics, and the ping-pong between counties. This is the balance between risk and rehabilitation. Do you think that was the right call?
Court calls the case of the people versus Brian Gerard.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Gerard, Your Honor. He's approaching.
Your name, sir?
Brian Gerard.
Thank you. Okay, what are we doing?
Your Honor, I've had a chance to speak with the prosecutor and speak with Mr. Gerard. He'll be waiving his exam this morning. Oh, date, it's 24th. I have explained to him he has an absolute right to that exam. I believe the people have agreed not to habitualize this matter. 24th.
Sir, you're waiving your right to preliminary examination? Gerard, you're waiving your right to a preliminary examination?
Yeah.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes.
You understand that you'll not have that hearing, you'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right.
Yes, Your
Okay.
Honor.
Preliminary examination having been waived, defendants bound over to circuit court on count 1 with 2 following.
Your Honor, we'd waive reading, stand mute, ask the court to enter a not guilty plea.
Defendant having waived formal reading, standing mute to both counts, court will enter a not guilty plea. Pretrial will be set for May 5th, 2025, 1:30, Judge Hamud.
Your Honor, I believe he has other matters set with Judge Hamud on the 12th. I don't know. Well, they'll just move him if he does. Thank you.
You're informing me of that because of why? You want me to give you the 12th?
I hate dead air.
What?
I hate dead air. No, the 5th is fine. Judge.
Okay, good. Thank you. Bond continue. I cannot figure everything out. Court does call the case, people versus Gervais Drake.
And then I have people.
Assistant Public Defender Jay Bellinger on behalf of Mr. Drake, who approaches, Your Honor.
Your name? Gervais Drake.
Your Honor, we're just asking to set for exam at this time.
Discovery is complete.
To my knowledge, yes.
People have their witnesses available to 6.
We'll do our best, Your Honor.
Preliminary examination in person, May 6, 2025, 12 noon. That's before me.
Thank you, Your Honor.
Thank you. Bond continue. Court does call the case, people versus Haley Gregg.
Jennifer Douglas for the people.
Oh, she was still here. I
I'm
told you.
back. Couldn't get rid of me that easy. Christina Costantino appearing on behalf of Haley Gregg.
Your name?
Haley Gregg.
Judge, this is the date and time set for PCC. I was just appointed quite literally about 10 minutes ago. So given that, I would be asking for an adjournment of the PCC.
Is this the only thing holding her?
No, Your
All right.
Judge, it was my understanding that her only other hold was a Melvindale misdemeanor warrant, and Melvindale has indicated that they would not pick up on that warrant.
Well, I'm just looking, do you want 12 days out or you want 1 week? Because she's in custody. So I can do the 1st or the 6th?
Fortunately, Judge, I'm in trial next Thursday, so I can't do
Can't
next.
do the 1st, so I'll set it for the 6th for BCC. It's a Tuesday.
I have a look at the 2,000 cash or surety bond on an RNO A and B case.
I thought you had a, you said you had
That's what he said, no.
After failure to appear.
All right, I'm just trying to get her, I'm just trying to give her the quickest date I can.
Understood, Judge.
So if you're not available the 1st, I'll do the 6th.
That would be great, Judge. Thank you.
May 6th, 2025. That's at 9 a.m. All right, for a probable cause conference. All right,
Thank you, Judge. I
thank you.
would also like to address bond. I know we've
You would.
touched on it a bit. It's my understanding her bond in this matter is 5,000 with a 10% bond. It's my understanding of the circuit court matter that I think the people were mentioning a second ago. My client tells me she received a personal bond on that file at her last court date. She is 34 years old. She does have employment lined up should she be released. She would be working at a medicinal cannabis retail store. She would.
Okay.
She does.
Like she has a job at a liquor store. Go ahead. No, I'm kidding. Go ahead.
Very important jobs. It's a very important sector of our economy. She does have housing lined up as well.
Wow.
She would be
You're vouching for that.
She would be able to reside in the city of Ypsilanti with a friend. She also is on the housing list through Avalon Housing. She would be working with CMH. She, previous to her incarceration, was working with CMH and attended therapy at least 2 times a month. It's my understanding that the other holds out of Wayne, as mentioned, they would not pick up on. We did ask the court to consider a personal bond. If the court is unwilling to do so, we would also ask if the court would consider release to treatment. She has indicated that she does think treatment would be appropriate for her at this time.
Kind of treatment.
Substance abuse treatment.
Ah, at the cannabis store. No, I'm kidding. Go ahead.
Your Honor, at this time, we believe that her bond is appropriate. She does have multiple other matters pending. We would point out that the date of offense in this case is the day after she was released on another case. I don't know if you remember Ms. Gregg from last time she was here. But Your Honor, given that she picked up this case.
Because she had to drive, because she had to get away from here after she was released. So she just grabbed a car. Whose car did she grab? Allegedly.
Allegedly, Judge.
Allegedly, did she? It was a police car.
No, what?
Okay, never mind. My bad.
No.
She just took a car because she had to go. Allegedly.
Allegedly, Judge.
And she's already had a failure to appear on the RNO case back in February. So we don't think that a reduction in bonds.
If I may, Judge.
Go ahead.
Judge, my only response to that would be treatment, I think would be perhaps a great middle ground for her. She's indicated a willingness and a desire to obtain treatment. Certainly, I think with treatment there, the risk of failure to appear is significantly diminished.
If you prepare an order, I'll release her on a PR to treatment.
Thank you very much, Judge.
Your Honor, could there be a tether to keep her in inpatient treatment at that place?
Well, I'm not really.
I don't know that she's gonna need a tether. I mean, if she goes into treatment. No, I'm not gonna do a tether on her. I'll just indicate that she can be released to treatment on a PR.
Thank you, Judge.
At this point, however, her bond will continue.
Thank you.
Court does call the case of the People versus Muhammad Farr.
Ready, Judge.
Andrew Childers, appearing on behalf of the people.
Court shall fix the first assistant public defender on behalf of Mr. Muhammad Farha. Please state your name for the record, sir.
Mohammed Farha.
Thank you, Judge. We are still in the process of trying to get this matter resolved. We are requesting a brief adjournment so he can provide proof of his treatment to the prosecutor's office, and we can hopefully find a resolution, Your Honor. He is in compliance as far as I can tell now. Last time we were here, you had him go drop and he dropped and came back clean, Your Honor.
I have proof of treatment with me right now.
Okay, well, he's gonna need time to review it.
Okay.
So you're looking for how much time?
Just a couple weeks, Judge.
Probable cause conference in this case will be adjourned May 6, 2025, 9 a.m.
Thank you, Judge. I'll provide that proof to Mr. Childers and try to get this matter resolved on that time.
All right. Thank you, Mr. Carr.
Yes, everything is still in place.
Okay.
Keep doing it. Thank you, Judge.
Court calls the case People versus Antonio Jackson.
Alexander, on behalf of the people, Your Honor.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Jackson. Will you state your name for the record?
Antonio Jackson Jr.
Thank you.
Your Honor, we're asking that this matter be set for a preliminary exam.
Your Honor, if I could address bond appropriate.
All right. Discovery is complete.
To our knowledge, yes, Judge.
People have their witnesses available to 6.
We'll do our best.
She's up.
Set preliminary examination in person, May 6, 2025,
9 a.m. before the hearing.
9 a.m. before Judge Perry. Yes, as to bound.
Your Honor, I do want to make the court aware, in checking the defendant's jail calls, he has tried to contact the victim 33 times since arraignment. She's not picked up the phone, but he has been trying to call her 30 times.
Any response?
No, Judge.
For Gregory Davis, the court allowed a 10% bond privilege. The defense stressed behavior change, detox, and job prospects. The prosecution highlighted safety concerns and new incidents. This is the bond tightrope: freedom versus public safety. Which side do you lean toward here?
Defendant's phone privileges at this time are revoked. Found otherwise will continue. Thank you. Yes, to the extent it's true. After the second time, why are you calling back? Never mind. Court calls the case People versus Durantu Francis. That's Suzanne.
Good morning, Your Honor. Assistant Public Defender Tanazi Carey accurately on behalf of Mr. Durantu Francis. Ms. Francis, state your name for the record, please.
To Francis.
Thank you.
The court should have a green sheet.
I do.
I think we did receive an offer today. We just need to relay it to Ms. Francis, and I think 2 weeks should be fine, Judge.
Probable cause conference, May 22nd, 2025, 9 a.m.
Thank you, Your Honor.
Continue. All right, thank you, ma'am. Case People versus Sean Johnson.
And is that on behalf of the people, Your Honor?
Mike Gaddy, Assistant Public Defender, Mr. Johnson. He's in lockup too. He's making his way to the.
What? I'm sorry. You're there. Johnson.
Your Honor,
state your name, sir.
Sean Michael Johnson.
Thank you. What are we doing?
Your Honor, we're asking you to set this for a preliminary exam.
Discovery is complete.
Your Honor, I have spoken with Ms. Zenda. There was some video. She says it's on our way to our office, so I'm confident.
And that's correct, right? There's a meeting, so it should be here by Monday. And if people could address bond when appropriate.
Preliminary examination in person will be set May 6, 2025. Huh?
Yeah.
It's at 12 noon before me. That's the bound.
Your Honor, this defendant has tried to contact the victim 29 times since arraignment with one completed call. And in this call, he talks to their child, who then passes the phone to the victim. And in that call, he asks the victim for money to put on his account and also tells her, you know, I'm going to prison, right? So I'm concerned that his phone privileges be revoked. We'll be asking the jail to block that number.
Yeah, I was made aware of this earlier this morning. I haven't had a chance to look into it. I guess if I'd ask the court as an interim provision to block that number, the alleged the number of the alleged contacts and not revoke the privileges. I believe the bond is currently set at 25,000, if I'm not mistaken.
If bond will continue, defendants' phone privileges are revoked. You can raise it if you find out something different at the time of his preliminary examination, but at this time they're revoked.
Thank you.
Court does call the case, People versus Lena Harbali.
People. Your Honor.
Mike Gaddy, Assistant Public Defender for Ms. Harbali, who's here to my right. State your name, ma'am.
Lena Harbali.
Thank you. Thank you. Your Honor, we are requesting an adjournment for this matter. We actually did submit a Zoom request, but Ms. Harbali was released from the hospital in time to be here today. So we are endeavoring to go to mental health treatment court. I have reached out to Mr. Graveline. I haven't heard back. Oh,
no, go ahead.
Whenever someone does something, I always think it's me.
No.
We are trying to get screened for mental health court. There was a delay based on.
Okay, no, that's fine. Probable cause conference, May 22nd, 2025, 9 a.m. All right, bond will continue.
Thank you, Judge. It's right on file.
Your Honor.
Thank you. Court calls the case, People versus Anderson Keller.
Good morning, Assistant Public Defender Davi Lebo, on behalf of Mr. Keller, who's approaching from my right. Mr. Keller, could you please state your name, sir?
Anderson Christopher Keller.
Okay, what are we doing?
Your Honor, we're here today for a competency hearing as well as a probable cause conference. I have received the competency report from the Center for Forensic Psychiatry and would be prepared to stipulate the results finding Mr. Keller competent.
Are you talking about the March 13th report?
Your Honor, I can double check the date on it, but I believe so. Actually, yes.
Are the people in receipt of that report?
Yes, Your Honor.
All right.
We would also stipulate we have no further reference.
Based upon that report, the court would find that the defendant is competent. Right.
Your Honor, with regard to the
report specifically would indicate that the defendant can understand the nature and object against him and can rationally assist in his defense. Therefore, the defendant is deemed competent. Do you have an order?
No, Your Honor, I can prepare one.
Okay. All right, what are we doing?
Your Honor, with regard to the PCC, would like to set this matter for preliminary examination, please.
You have all the discovery?
Yes, Your Honor.
We'll be able to have their witnesses available to 6.
I don't know, Your Honor. I'll try for that date.
All right. Preliminary examination will be set May 6, 2025. 9 a.m. before Judge Perry.
Thank you, Your Honor.
Court calls case People versus Brian Howell.
Ashley Money for the people.
Your Honor, Constable Bass on behalf of Mr. Brian Howell, who is present to my right. Mr. Howell, can you state your full name for the record, please?
Good morning, I'm Brian Howell.
I have before me a pay form. Is that what we're doing?
Yes, Your Honor.
Plea form indicates that he's going to plead to use of a controlled substance to 1 year misdemeanor. Upon a successful guilty plea to that charge, count 1 would be dismissed. Well, hold on a second. He's also going to plead to counts 2 and 3 as charged.
That's correct, Your Honor.
So he's pleading to counts 2, 3, and 4.
Yes, Your Honor.
Correct, Your Honor.
And then, okay, and then count 1 is dismissed. That's the court's full understanding.
Yes, that's correct, Your Honor. And my client is looking to get into the drug treatment court over in Oakland County. He has spoken with them over there, but it's pending this plea so that we have this done.
So with this plea, he'll be able to get in?
Correct.
Okay. All right. I know we've been trying to do that a minute. May I have him sworn?
Right. Do you solemnly swear and affirm the testimony you're about to give? Do you solemnly swear and affirm the testimony you're about to give with the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
State your name.
Brian Howell.
All right. Sir, it is this court's understanding that you're going to plead guilty to 3 misdemeanors. Is that correct?
Yes, Your Honor.
All right. First of all, that you're going to plead guilty to the stated count 2 of operating with your license suspended, denied, and or revoked. That's a misdemeanor punishable by up to 93 days, $500 fine plus court cost. Vehicle could be subject to mobilization. Understand that?
Yes, Your Honor.
Count 3 also that you're going to be pleading guilty to is the charge of open intoxicants in a motor vehicle. That's a misdemeanor punishable by up to 90 days, $100 fine plus court cost, community service, and any substance abuse treatment. You understand that?
Yes, Your Honor.
And then also that you'd be pleading to the charge of use of a controlled substance. That's a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court cost. You understand all of that?
Yes, Your Honor.
All right. And you understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A4 District Court.
Yes, Your Honor.
Understanding that you still wish to plead guilty to these charges?
Yes, Your
Honor. To the charge of driving while license suspended, denied, and or revoked, how do you plead?
Guilty.
To the charge of open intoxicants in a motor vehicle, how do you plead?
Guilty.
To the charge of use of a controlled substance, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form?
Yes, Your Honor, it's here.
You signed an advice of rights form?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
Yes, Your Honor.
Were you on probation or parole at this time of these offenses?
Yes, Your Honor.
All right. Then I need you to understand your plea in this case could be a violation of that probation. And you need to understand that as such, that other court could sentence you to the maximum allowable under those other charges. You understand that?
Yes, Your Honor.
And understanding that, you still wish to plead guilty to these charges?
Yes, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will,
Yes, Your Honor.
and because you believe that you're guilty of these offenses?
Yes, Your Honor.
March 17, 2024, at the location of M52 near Newkirk Road, Manchester Township, Washtenaw County, State of Michigan. Were you operating a motor vehicle?
Yes, Your Honor.
At the time, was your driver's license suspended, denied, and or revoked?
Yes, Your Honor.
And did you know that it was?
Yes, Your Honor.
All right. And while you were operating that motor vehicle, did you have open intoxicants in the motor vehicle?
Yes, Your Honor.
What'd you have?
I had an open tall boy, which is an open beer.
Really? Like I didn't know, because I just crawled from under a rock. I get you. You had an open beer in the vehicle, right?
Yes, Your Honor.
Okay. And you knew it was there?
Yes, Your Honor.
All right, and it was yours?
Yes, Your Honor.
All right. And had you used a controlled substance on that day?
Yes, Your Honor.
What?
Adderall.
All right. Did you have a prescription for it?
No, Your Honor.
All right. And you knew what you were using was Adderall?
Yes, Your Honor.
All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Defense is also satisfied, Your Honor. Thank you.
Court will accept the defendant's pleas of guilty to counts 2, 3, and 4. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14 and 4 probation. Sentencing will be June 10th, 2025, 9 a.m. before Judge Freshour. Bond on this will continue. Mr. Hall, good luck to you, sir.
Thank you, Your Honor. It's been a pleasure.
Thank you.
Court does call the case of People versus Michael McLean.
That is on behalf of the people, Your Honor.
Phone privileges revoked after repeated calls to the victim? The message is crystal clear. Victim safety comes first. The judge left the door open to review later, but for now, it's a hard stop. Would you have gone softer and just blocked the number? Or was this the right move?
Basically, on behalf of Mr. Michael McLean, who is present to my right, you state your full name for the record, Michael.
Michael James McLean.
Thank you.
Today is the date and time set for probable cause conference. At this time, we'd be respectfully requesting to set this for a final settle. I'm sorry, not final settlement, preliminary exam.
And your people can address bond.
Yeah, of course. Hang on. Would people have their witnesses available on the 6th? Preliminary examination in person, May 6th, 2025. 9 a.m. Is it 12? 12 noon. That's before me. Yes, that's the bond.
It's come to my attention, he has made 127 attempted calls to the victim since arraignment was 2 completed on 4/16 and 4/8.
How many?
127 attempted calls, 2 were completed. So I'd be asking that his phone privileges be revoked.
Oh. Response?
No comment at this time, Your Honor.
His bond will continue. His phone privileges are here revoked.
Thank you, Your Honor.
I was married 15 years. It's all set. Pause the case, People versus Zakaria Haruska Dennis.
Rachel McDuffie for the people.
What?
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Haruska Dennis.
No, wrong. Doesn't matter, he's not here.
Just for the record, I'd ask for an adjournment. He did reach out earlier this week and left a voicemail. I attempted to reach out and follow back up. We are missing some outstanding discovery, but I don't have an answer for his non-appearance today.
Bench warrant will issue. Bond 10,000. Cash surety, that warrant will issue immediately for Mr. No. I'm telling you. Court calls the case, People versus Robert Mitchell.
Council Bashir with and on behalf of Robert Mitchell.
Robert Mitchell. Thank you, sir.
To our knowledge, discovery is complete and we request the earliest possible exam date that the people can accommodate.
People have their witnesses available to 6.
We'll try, Your Honor.
Preliminary examination in person, May 6, 2025, 9 a.m. That's, is it 9?
Yes.
Before Judge Perry.
Thank you, Your Honor.
Thank you, Bond. Thank you. Thank you. Court calls the case, People versus Anthony Johnson.
Alice, and on behalf of the people, Your Honor.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Johnson, who appears to my right. Mr. Johnson, can you state your name for record?
Anthony Johnson.
Your Honor, we submitted a waiver request on this.
All right. So you're waiving your right to a preliminary examination?
Yes, sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand that you won't have that proceeding and to proceed to circuit court for further resolution.
Yes, sir.
People also waive the right.
Yes, sir.
Preliminary examination having been waived, defendants bound over to circuit court on counts 1 and 2 with 3 following.
Acknowledge receipt of information, Your Honor. Wait for my reading, stand mute at this time.
Defendant every way for reading, standing mute to all counts. Court will enter a not guilty plea. Pretrial will be set for
June 17th, 1:30 before Judge Conkey.
June 17, 2025, 1:30, Judge Conkey.
And Your Honor, if we can address bond briefly.
Okay.
That's far out.
It has come to my attention from the victim, she sent us a screenshot that the defendant has sent her a Facebook request, friend request. So that concerns he's trying to reach out and contact her.
Your Honor, in talking to my client, we have decided to address this issue head on. My client has an explanation for this that he would like to offer to the court.
Go ahead. Is he admitting to that?
Yes, sir.
Mr. Allen?
He is admitting to that, Your Honor. The explanation is. You want me to?
I can say it.
Okay.
It was a mistake. I push and remove and push add frame. That was simple. That's what I did.
Your Honor, he tried to eliminate the possibility of any contact. He saw that she popped up. He wanted to remove any possibility that he could have contact with her. That was his intentions. And
how did that even happen though?
Just
okay.
Big thumbs, Your Honor.
I was a mistake, sir. I admit it though.
He didn't intend to contact her. There's no allegation that he actually made contact with her. Like I said, he wanted to eliminate the possibility of that. He made a mistake.
Nope.
Hold on.
In reporting the violation to us, I believe she told us that she had made an entirely new Facebook account, not using her name, and that was the account that sent a friend request to. She wasn't sure how he found that account, but he added her as a friend and should be this report.
Your Honor, the only thing I can provide is that when new accounts pop up, the suggested friends that pop up, he likely noticed that it was probably hers. He intended to remove it to eliminate any possibility of contact. He immediately, when he clicked add, he immediately went back and clicked remove. Realizing the mistake, he blocked her. Again, there's no allegation that he actually had contact with her. He doesn't want contact with her. He understands that he's on bond and he doesn't want to do anything to lose that. And
do not have or attempt to have direct or indirect contact with the above individual in person or through others by electronic communication, including but not limited to phone, email, texting, internet, or social media.
Well, Your Honor, if it was not under her name, I don't know how he could possibly have also known that it was her definitively.
Then why would he have attempted to remove it?
Because the possibility that it could have been, I imagine. He advises that it was her face. So he wanted to.
He knew.
Well, Your Honor, he is just providing an explanation as to why he wanted to eliminate the possibility of contact. It did pop up. He did remove it. He's asking that the court. He blocked her. He is asking that the court take that into consideration. He's asking, we are pleading with the court to allow him to remain out on bond at this time. And he was, for what it's worth, honest with the court about that. He is taking accountability for it.
Anything else? Tell you not to have contact. He sees her face. He attempts to make contact with her. He can't violate the bond that way. Just plain and simple. Defendant's bonds revoked. Defendants remain. Close case, People versus Bruce Pickens.
Stephanie Can on behalf of Mr. Pickens, who is appearing to my right. Mr. Pickens, could you please state your name for the record?
Bruce Pickens.
Your Honor, you should have a green sheet in your possession. I'm simply asking for a 2-week adjournment. An AIM request has been done for my client to see if we can get some mitigation.
Said 2 weeks,
Yes, sir.
and you 12 days, so I'll set probable cause conference in these matters will be May 6, 2025, 9 a.m.
Also see you before then, and you'll hear from our staff to try and get you some mental health and also start working on a home.
Bond will continue. Thank you.
Thank you.
Case People versus Marcus Jones.
Judge.
Hey, how you doing? I'm doing.
Worship Feaster, First Assistant Public Defender on behalf of Mr. Marcus Jones. Mr. Jones, please state your name for the record.
Marcus Jones. Thank you, sir.
People.
Thank you, Judge. I think we were here a couple weeks ago, which time Mr. Jones was in treatment. He is now out of inpatient treatment, out of the hospital, but he's going to be going back into a outpatient.
Patient
Yes.
program.
So my understanding is once he completes that, that might have an impact on the resolution in this case. So I'd ask for 3 or 4 weeks or more adjournment so we can get him going.
If I may, Your Honor, I did attempt to do I'm sorry. I did set an appointment for myself, but I missed it, so I had to reschedule another appointment. So I was planning on scheduling another appointment after court today.
Today. Okay. All right, real good. Let's do this then. Let's see how you're doing through the program and everything. I'll adjourn it out to May 29th.
Okay.
Okay. Thank you.
Okay. You're welcome. 2025, 9 a.m. Okay, you take care of yourself, young man.
Got something right
Yeah,
now.
I'm making a call out. Okay. Thank you, Judge.
Court calls case People versus Scott Reese.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Reese. Please state your name for the record.
Scott Reese.
I think we're going to be filing a no leave cross in this case.
Any objection?
No objection.
Case is dismissed.
Missed all 3 counts.
Okay, thank you.
You're welcome.
Thank you, sir. And then why were you like giving him the fist like you did something? You didn't do nothing. You did nothing. You did nothing. That was Miss Apple's victory. You just, you know what? Just don't even try.
That's all for one, Your Honor.
Court calls case People versus Maurice Kihei. Or Kihei.
And then on behalf of the people, Your Honor.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Kihei. Mr. Kihei, can please state your name for the record? That's how you pronounce it, right?
Yeah.
Okay.
Marty's Kihei.
Kihei.
Your Honor, can you briefly approach?
Oh, boy. Bellinger, really? It's like every week. This is a prop.
Every week?
Yeah.
When's the last time I was at this bench?
Last week. Yeah. It was.